That's the inference, and I don't agree with it.
Right, the next question is from Stephen.
Yep.
Steve.
Two questions. First one was when the Federation was founded and the Constitution was formed, we're all British subjects. That consequently changed, I think, with the Nationality Act of 1948. Does Parliament within the Constitution, or does the government under the Constitution have the power to alter our nationality? So that's the first question.
No, everybody who is born in Australia or becomes a naturalised Australian obtains Australian citizenship. It's not within the power of the federal parliament to declare somebody who is an Australian citizen to be a citizen of some other country. It can't be done.
Is it Australia ship? Well, you're giving citizenship.
Citizenship, yeah.
So Australia is a ship, yeah? Is that true or is it not?
Well, yeah, we can call it a ship of state, and we're all on it. Yeah.
Oh, so maritime law?
Not quite.
No?
No.
How's that?
Citizenship is just a word which means...
Citizen on a ship?
No, it doesn't mean
No?
It doesn't mean that.
You're speaking some different English.
Yeah?
Do you?
Yeah, well...
All right. Now, did you have another second question,
No,
Steve?
I just want to clarify that because when the Constitution was formed in 1901, we were all British, and that subsequently changed. So what power or authority did Parliament have, or the government have, to alter us from being British and Constitution to then becoming Australian?
Well, because we adopted an Australian Constitution and therefore we're no longer subject to the rule of the UK. Once having adopted our own Constitution, then the power to determine citizenship moved from the United Kingdom, where it originally vested, to Australia, and that's how we come to be Australian citizens now.
Now, we have a lady very persistently waving her hands at the back. I don't know your name. If you'd like to introduce yourself.
Is it on?
Speak out loudly so that we can hear you and address your question to the learned professor.
My name is Yvonne Gentle. I come with Jim and Leanne tonight. In your opinion, Professor Zifchak, if the Constitution is taught and is in our universities, in our law schools, etc., etc., why are the judges, the lawyers, and whoever else is in the profession, why are they not enforcing it? Why are they not using it in our court system? What has happened? Why are they using the Australia Act and sticking it in front of our Constitution and going by those laws instead of the Constitution?
I don't believe that they are.
No?
I don't believe that they are. The ultimate power in determining the meaning and effect of the Australian Constitution resides with the High Court of Australia. And the High Court of Australia has been interpreting the Constitution and giving it meaning and effect, including on matters such as the relationship between the federal and state government, including, for example, interpreting that provision which we were looking up at before about what it means for a state law to be inconsistent with a Commonwealth law. The High Court, that's its primary job, to give effect to the Australian Constitution. And that's what it's doing. Now, you may not agree with every decision that the High Court has made about what the Constitution means. And if you don't, well, get in there and criticise it. No problem. No problem.
Yeah, it's a problem.
No problem. No problem.
They don't want to hear it.
Yeah.
Exactly.
But the reality is, it is not true to say that the High Court of Australia has been bypassing the Constitution. That is simply wrong.
So
What it is doing is it's interpreting the Constitution.
Isn't a people's interpretation more important than the High Court judge?
No.
I haven't finished.
Well, isn't this aren't we in a sovereign country where the people are free?
Yeah, it's a very important question. I'll come to it, but let me just finish with this.
Okay, so then there is obviously, in situations where someone has come to court and has to face a magistrate or a judge, even as like Jim was in the county court, when asked or challenged about these things, about the Constitution and knowing their rights according to the Constitution, why is it then that a judge will get up and walk out if he can't answer the question?
I heard what the gentleman had to say about that. I found it very interesting. But forgive me, I'm a lawyer. I can't make a judgment about what happened unless I get the evidence from more than one person. I've got to have a bit of corroboration.
You are in their club.
Now, Mark's been patiently waiting to put a question for the last 3 questions, so we'll call on Mark Wheatland.
What's your opinion on what Darryl said about the first page of an act? If the separation of the powers haven't been enforced, so for example, the state government enact as follows, as compared to Her Majesty enacts as follows.
The situation with that's pretty clear, actually, and it's set out in this document we've got here. For an Act of Parliament to become law, 3 things have to happen. And it's the same at the Commonwealth level and at the state level. The bill, that is the proposed law, has to be passed by the lower house of the Parliament. It has to be passed by the upper house of the Parliament, and it has to receive royal assent. Okay? Now, let's presume for a minute that an act was passed by the lower house of a Parliament and by the upper house of a Parliament, say Victorian Legislative Assembly, Victorian Legislative Council, but it didn't go to the Governor for final approval. It wouldn't be a valid law. Okay? But as long as those 3 steps are set in place, then under our Constitution it's a valid law.
So you think we've got separation of powers then?
Well, let me answer that question because it's quite an important question. We have to be very clear on what the separation of powers means. And the explanation you were given about that before was exactly right. The separation of powers means that the powers of government are divided between 3 different arms of government. Okay? So you've got the Parliament, that's one arm of government. You've got the executive, in other words the government, that's another arm of government. And then you've got your judiciary, which has to be independent of the Parliament and the executive. Let me give you a very simple example of what that means. Take a taxation law. Okay? Legislative power rests with the Parliament, which is the arm of government that enacts the law. Okay? That's what the Parliament does. Okay, so it enacts the Taxation Act. Right? It enacts the Taxation Act. And I can see you've got more questions.
Look, we'll get to the end of this question and I'll explain that what we're going to have to do, because we'd be here all night and half tomorrow if we took all the questions.
As it happens, I've got more answers than you've got questions. All right, Parliament makes the law. Okay? The government, or what we call the executive, administers the law. That means it establishes a taxation commissioner to administer the Tax Act. And where there's a dispute between the government and the taxpayer, you've got the courts to adjudicate the dispute between the government and the taxpayer. Now that's how it works, right? Parliament makes the law, the executive administers the law, judiciary interprets the law and resolves disputes. That's that's what the separation of powers means.
But that law should be interpreted before it's placed upon the people. Australian Courts Act 1828 has to go to the court and be enrolled with the courts as a valid law, and it doesn't.
No. Once the 3 steps I talked to you about before have been completed, that is, lower house, upper house were assent, then it's a valid law. Now, that doesn't mean that if you've got a dispute with the Commissioner for Taxation about a tax law, you can't go to court and say, the Taxation Commissioner thinks this law means one thing, I think the taxation law means another thing. Now, it's up to you, the judges, to decide what the law actually means. Now, your question is right to that extent, but you're not right to say that to become a valid law, it has to go to the judiciary to be validated.
Look, just a minute, before we go any further, I'd just like to put something to the Professor. We're going to have a lot of questions here that really will require, or the people will...
Can you come back and...
Won't have enough time to ask and answer tonight. Do you have an email address where these people could direct their questions, or the meeting could direct questions, and perhaps you could give us time, or give us some of your time to look into the question and give us an answer. For some of the curly ones, just, you know, it's nearly 8:30 already. Time just flies when you're having fun. That's what's happening here. So if that could be organised, that would be most gratefully received by the people here. We've nearly all got email addresses. Put your hand up who hasn't got an email address. We've got one. Right. Okay, so practically everyone's got an email address. You nearly all take notes. So if there's an email address made available, that could be most useful.
Just one thing about that. As you can imagine, I'm running about 3 different jobs at the moment, so I'm busy. So I'm happy to answer any of these curly questions, but could I suggest that you first email them to your chair, or
email them to Darryl or myself, and we can act as a developer
send me
and work it that way. That's the best way to do it. Okay, we've got Bill over there waving his arms like that. Bricklayer from Baghdad.
Well, Professor, in regards to the Constitution, if I make a request to a judge for application of the Constitution, a law of the Constitution, and I'm denied purely on monetary grounds, does that tell me that the judge has full discretion, regardless? I mean, they can make any choice they want, regardless of constitutional law?
I'm not quite clear on your question. Explain it to me a little better.
Well, in regards, we have our constitutional law. I'm sure, like you said, as a lecturer, you've informed a lot of people, in particular the judges and so forth. So they're well aware of it. So if a member of the public actually makes the application of constitutional law, then why would a judge deny the application of the Constitution on monetary grounds? Now, is that something that the judge, it's their own decision? I mean, do they sort of negate the constitutional law?
What I don't understand about your question is what you mean by monetary grounds. What do you mean?
Well, I just need to throw it in.
You want a constitutional point clarified because you've got a case before the courts that means that you really need to have some sort of constitutional decision. Is that what you're saying?
Well, that's right.
Yeah.
Yeah, I was making a request for trial by judge and jury, and I was told I was denied purely on monetary grounds that it would be a burden of the public, and I had every right to apply constitutional law according to an indictable offence. So, I mean, does that make any sense to you?
People be denied justice and not having the money.
Yeah.
Yeah, well, this is a huge problem. It's a huge problem. And the problem is serious, right? Serious.